You're listening to Talking Freely, where we discuss culture, politics, and religious freedom. Talking Freely is a podcast from Freedom for Faith, a Christian legal think tank that exists to protect and promote religious freedom in Australia.
Welcome to Talking Freely. My name is Rowan McHugh. With me today is Amanda Stoker, who has represented the state of Queensland in the Federal Senate since 2018. Senator Stoker arrived in politics after a career in the legal profession, commencing her employment at Minter Ellison. Becoming a barrister, she practiced commercial law, administrative law, and corporate crime. She's been a member of the Liberal Party since the age of 19 and is motivated by the desire to see Australia return to a country of opportunity based on centre-right values. Senator Stoker, welcome to Talking Freely.
Thanks, Rowan. I really appreciate the opportunity to be on your podcast.
Given that you were a successful lawyer for many years before entering the Senate, could you run through some of the reasons why you felt that political participation would be an effective use of your gifts and talents?
Well, I hope I'll be effective. I'm always giving that a crack. Look, I came to politics after having been involved in the LNP for a long time. I was very clear about what my sort of conservative worldview was, and had a strong belief that we all as citizens have an obligation to do what we can to contribute to our democratic processes and do our bit to make Australia a little bit better. But at the time the opportunity to run for pre-selection came up, I confess I was very frustrated with some aspects of the way Australian politics and culture in particular were going at that point in time. There was a real sense that it was becoming very intolerant to people who had beliefs that were like mine, and I didn't want to see this country continue down a path that could one day make it so divided or so hostile that my children couldn't grow up free to find and grow and express a faith. To me, that's one of the most fundamental freedoms that we all have. It goes to the core of us having agency as human beings, that there is no greater liberty than the ability to think and decide what you believe in. So when the opportunity to run came up, and I had been kind of banging my head against a wall a bit, trying to get other people to do something about it, there came a night where my husband said to me, you know, Amanda, you might have to do this. And initially there was a bit of an eye roll. Really? But we thought about it, we prayed on it, and as it turns out, it has been an enormous privilege and a great opportunity to try and do my bit, play my part in making sure we get these things right for the future.
Over the last 50 years, Australia has increasingly become a multicultural, multi-faith and secular society. What does good representation in the Senate look like, given that this has created so many different views of human flourishing?
That's a really good question. There's obviously a different kind of dynamic in the Senate to what you get in the House of Representatives, because you're more likely to get minor parties and their views getting a fairly loud mouthpiece. And oftentimes people of faith find those minor parties very appealing because, in a sense, they can offer a degree of very close alignment with the things that are important to them, although they very rarely get more than the one or two people that the system can deliver for any very kind of particular worldview. The challenge, I think, comes not just from the diversity of representation that you get in the Senate, though. I think the challenge comes from the cultural forces that have produced what we've got by way of representation in the Senate at the moment. And in terms of delivering a parliament that can produce laws that value all of the different faith traditions that Australians come from, it, I think, is far more problematic that we have a culture that drives too much from an identity politics base, which thinks of diversity in terms of racial difference and other sort of genetic or inherent attributes that we can't control being protected and elevated to a different status. And I think that driver for things is a little bit less helpful. It would be far more useful if people approached their work in the Senate from the perspective that our society has grown and flourished and become free and strong because of a cohort of principles. And when we stick to those, no matter what colour, creed, sex, whatever you come from, the most number of people get to, in a sense, choose their own adventure. And that delivers a fairer and more free environment for everybody. So when I say that, I mean the principles of intellectual freedom, freedom of speech, freedom of association, the rule of law, the idea that we're all equal before the law. These kinds of concepts have delivered more freedom and more prosperity in many ways than any other system that we've had in the world in all the history that we know. And it is the drift away from that, which has the drift away from that and to identity politics, particularly in the Senate, that has created a lot of the impetus for a concern in parts of our community and from many faith traditions that they may not be welcome in parts of law and culture.
Drawing on your legal expertise and experience over the last 15 or so years, and from what you've witnessed in terms of court rulings and changes in legal interpretation and jurisprudence, is there anything that troubles you about the trajectory we're on in regard to the law?
Yes. Whether they admit it or not, a large chunk of our legal profession are quite sympathetic to many of these identity politics type causes. They tend to like concepts like bills of rights, and those types of instruments invite what many people term judicial activism. And judicial activism is the disturbing, I think, phenomenon of judges being invited to and accepting the invitation to rule on matters of politics and policy in their decision making, and in doing so encroach upon the work of elected and accountable parliaments. In doing so, we end up getting changes to the law that the Australian people didn't ask for and can't do anything to stop, because it's happened outside of the processes by which they can say, we didn't like that, we want to change our government and get a different approach. That's even more intense in circumstances where you bring in bills or charters of rights, because in what looks like a piece of legislation that is going to protect and entrench things that in a broad brush sound nice, who doesn't like human rights? Everybody likes humans having fundamental rights, right? But it's at the moments when those things clash and you've got to choose which right matters that we find too often the rights of people of faith get squashed. It's when we need to understand how these rights intersect with other laws that we find the will of the Parliament, which is a representation of the accountable will of the Australian people, gets trampled, gets confined, and there's very little you could do about it. And the international human rights law movement, which has permeated our profession so thoroughly through, I think, the enthusiasm of law schools for the concept, and the way that has manifested, particularly in bills of rights, is, I think, a significant problem emerging from the profession that has the potential to, despite its good intentions, threaten a lot of the things that we really value.
One of your areas of interest is the history of human rights laws. When we examine the development of rights in the post-war period, there was a significant shift in thinking, particularly in how we understood the source of and nature of rights. Can you touch on the concept of natural rights and describe how that period of history continues to shape our thinking today?
I can give it a crack. So it was in the post-World War II era that this notion of codified human rights started to emerge. And in a historical sense, you can understand that. We've just gone through the horror of World War II. Human beings had done to other human beings things that still rock our sense of right and wrong to this day. Absolutely abhorrent travesties like the Holocaust. And it is quite natural, I think, in that environment that people said, well, we need to do some things to make sure that can never happen again. Totally understandable sentiment. And so a process was embarked upon to try and get down onto paper some things that all nations could agree on as being the core of what it means to be a human. The things that were non-negotiable in the way that we treat each other and in the way that governments relate to citizens. But up until that time, it's not as though people didn't have any protections for their fundamental rights. It's just that the way we understood it was different. We understood then from the concept of natural rights, the idea that what made us human, what made us dignified, what made us entitled to being treated in a way that respected human dignity came from our status as creatures of God. They were gifts of God. They were a reflection of the divine. And it shows because in the pre-World War II period, it's not as though we were in that period immediately prior utterly oppressed. It's not to suggest that there was perfection or that there weren't some people who were being treated poorly, but to suggest that before international human rights law came on the table, you didn't have free speech is false. To suggest that before international human rights law came to the table, we didn't have freedom of association or freedom of thought or any of the kind of individual liberties that really are the core of what you get in the ICCPR, the International Convention on Civil and Political Rights, is really not true. We did have those core rights and they were protected through the common law, which really did evolve from that tradition. So ever since, particularly in the English tradition, at the time of the Magna Carta, that had been evolving in a way that really was doing a rather good job of making sure that fundamental liberties were recognised. What was interesting, though, about this attempt to formulate a codified international human rights law in the post-World War II era is that the political tensions of the time manifested in those negotiations. I'll give you an example. In the way that the protection of discrimination against race or discrimination on the basis of race was dealt with in those negotiations, there was a real clash between the Western worldview and the communist worldview, reflecting that Cold War kind of tension of the time. The way that the language was framed around racial discrimination at that point in time attempted to protect people from discrimination on the basis of race as a facet of prohibiting speech that was fascist. When you might go, well, fine, fascism bad, like have a look at what happened in Italy and Germany during World War II. Fascism is bad. But if you look at what the USSR representatives meant by that, the way they used the term at the time, fascism meant anything that wasn't communist. And so, I mean, that's one simple example, but throughout the language that's used, you see inserted into these instruments, with one hand, the giving of a protection, with the other hand, placement of restrictions on speech, on communication, on thought, that in many ways empowered the dictatorial, that reflected the many things that particularly the USSR wanted to be able to implement not only at home but to export at that point in time. So we ended up with a whole lot of concepts being bundled up and codified as part of this international human rights law push that sound great, but that when you get into the detail, they're a real mess. And in many ways, they cause more problems than they solve. That will be a controversial point of view for many in the legal profession, particularly given, almost all the idealistic kids that graduate from law school come out saying they want to be an international human rights lawyer these days. But it's nevertheless true. And the product of it is the acts that we have here in Australia now that protect people from discrimination on the basis of a range of attributes, largely that they cannot control. They are protections based in identity politics. They are, by their very nature, divisive. The intention is good. I don't cavil with that. But in their effect, they attempt to confine the natural rights of individuals to think and to speak and to manifest their beliefs, even where it doesn't truly, in the traditional sense, harm others, and to do so on the basis of something that reflects an attribute with which a person is born and has very little control over. Now, I have problems with that, not just because there is divisiveness in it, but because this is a path that has almost been gone down unthinkingly. And it's not until recently when we've seen many people of faith start to find really quite unreasonable restrictions on their ability to practice that faith that we've started to go, well, hold the phone, this isn't working. That's confronting for a lot of people, but it's even confronting for many people of faith, because you hear often in the language of people in churches and synagogues and mosques and the like, a lot of talk around human rights. And yet the very concepts that they, in good nature, have tried to advance are in many ways the same concepts that are standing in the way of people being able to truly come to faith if that is their choice. And I think that's a really interesting historical and political phenomenon.
You've just mentioned the notion of harm there, and a strong tendency within rights discourse is to determine the goodness or badness of laws and freedoms on the basis of harm and the harm that they cause. This seems to disproportionately impact religions that hold to unchanging principles. How can people of faith navigate the claim that their beliefs cause harm?
That's one of the real challenges of our time, and it's a cultural challenge, I think. I'm sure you're young enough to have grown up in the time where you've observed this shift from people being raised along the lines of sticks and stones may break your bones, but words will never hurt you, to a time when children are being raised to think of words as violence. That poses really serious issues for people of faith, where some of the tenets of the faith challenge the mores that are in vogue. And if you choose to live according to values and to speak and to share values derived from your faith that don't fit the values that are in vogue, I'm sure listeners who have given that a try will know that you pretty swiftly face the wrath, whether it is on social media of haters, whether it is of the HR department in your workplace, whether it is of a tribunal if you're speaking out loud in the public sphere, and even in private correspondence, that can get you hauled before a tribunal. That's very intimidating for the meek who seek to inherit the earth. And that, I think, reflects the culmination of the weaponisation of identity politics through these legislative instruments derived from international human rights law obligations. It reflects a cultural tradition that is now saying it's not enough just to protect one another from physical harm. We need to protect one another from emotional harm, and emotional harm can be caused by words we don't like, words that are an affront to the way we choose to live our own lives or an affront to what we think is right and wrong. That itself, I think, is quite significant in this process. And the entire experience, I think, is exacerbated by the fact that in a world where we do so much of our communication in a digital sense, rather than face-to-face with neighbours, people skip from hearing words to frothing outrage in a heartbeat, because they don't necessarily have the context of knowing the goodness and humanity of the people with whom they are engaging. All of that drives an environment in which it has become almost dangerous to express an unfashionable but faith-based view. So your question was, what can What can people in that situation do? The answer, I think, is they can find courage in numbers, push back on the cultural tendency that words are violence, and in doing so, raise the next generation of people who are more resilient and who don't melt like a snowflake when they hear something that challenges their worldview. We can do that by being braver ourselves in the conversations we have with friends and neighbours and family. We can do that by insisting that our educational institutions genuinely provide an intellectually rich environment where people are exposed to different points of view in the course of being educated. And if you're not finding that in your public university, for instance, or your public school, finding a place that does, and they do exist. We can do that by becoming more active citizens and participating in the political process more to make sure that we, as far as is possible, have laws that reflect the kind of tolerance for ideas that we need if we're going to be genuinely able to cope with different perspectives. But we can also help through sustained political engagement to shift this narrative that says we all have different challenges and vulnerabilities and they all need to be protected by law, and instead go, let's reimagine this and say, how about we don't have laws that demand we be good to our neighbour? How about we return to the primacy of civil society and a small government that isn't going to be your thought police, but that instead will just protect the public space as one where we can all speak without fear of violence, and in doing so, increase the duty on individuals and groups of individuals as active citizens, engage with this, get to know and understand and share with their neighbour, and in doing so see the good in one another in a way that genuinely breeds harmony and tolerance.
One of the things that may contribute to this is the popular misconception surrounding the issue of the separation of church and state, which is commonly understood as religion being excluded from imposing itself on what are state matters. Can you explain your concerns with this idea and why religion ought to have a place in Australia today?
Yeah, there is a real misconception. People often, in a relatively glib way, will say to me, well, what about Section 116 of the Constitution, separation of church or state? And I feel like saying, mate, have you read it? In many ways, that provision, I mean, it does a couple of things, but in the relevant sense, it protects religion from the state. That's a very, very different thing. It protects us from any one religion being imposed upon us as the state religion, you know, the one faith that is the faith of the Australian government imposed upon us all. In that sense, there is an element of religious freedom to it. It prohibits making a religious qualification for holding a public office. So you can't say, for instance, only Baptists are allowed to run for Parliament, or only Catholics are allowed to be in the public service, for instance. I'm sure all Australians would think that was a sensible thing too. But it doesn't prevent or indeed suggest that there is no place for faith in our public dialogue. And in fact, it has always played a part and shaped the laws of this country. And that's for good reason. It is a terrible mistake to say that there is no place for religion or faith in the political sphere. Now, what does that mean for now? Well, for all of the talk about how we are a secular society, I prefer the term we are not sectarian, in the sense that, you know, we don't prioritise or prefer, say, Protestants over Catholics or anything like that, in the way that might historically have been the way socially things might have been organised in some parts of the country. It's far more useful, I think, instead of focusing on declining rates of religion, as you often see in news articles, instead to focus on there's still a large number of Australians who are deeply motivated and committed to their faith. The census tells us every time the vast majority of Australians identify with some kind of faith, and overwhelmingly that's Christian. It's not a bad thing. It's really not. Indeed, it drives among the most charitable conduct in our community, the most pastoral and supportive activity in our community. It does really, really good stuff, and it has a place. It pays a dividend, although I don't like a monetary kind of reference, but it pays a dividend that multiplies throughout our community. that extends everywhere from, helping someone who's fleeing domestic violence through the packs you often see being put together at churches, right through to making our education system viable, because there's no way our country is capable of publicly educating all of its young people. The religious sector plays an important role in making sure that we deliver not only choice, but sheer numbers in our ability to educate Australians. Although we shouldn't undermine the importance of that choice, I think it's very important. So it absolutely has a place. And people who say separation of church and state in a glib way, in many ways miss the point. And so there's nothing inappropriate about saying faith is important to many people, and there is nothing harmful to our institutions or our body politic that comes from making sure people are free to come to their faith in time, in their own time, I suppose, in God's time, and to think about that, to meet and discuss that, and to manifest it in their lives. The thing I always find interesting about the way some people argue this case, they say separation of church of state, it is therefore wrong to have protection of religious freedom. I think that could not be more wrong-headed. I think it really reflects an enormous misunderstanding of what it means to have a separation of church and state.
Turning to some of the things that have happened during your time in the Senate, in 2018, Senator Penny Wong introduced a bill to the Senate that would have removed exemptions for religious groups from the Sex Discrimination Act. You were a strong advocate for keeping the exemptions in over that debate. Can you talk through that episode, giving us your thoughts on those exemptions and what impact the bill would have had on religious institutions?
Yeah, sure. Look, I thought that bill was a really awful one for a number of reasons, but its effect would have been to, under the cover of saying schools shouldn't be able to discriminate against gay kids, that was the glib one-liner that Labor and particularly Penny Wong got into the press. Under that cover, it sought to effectively strip the ability of faith-based schools to teach those aspects of their faith that had the potential to offend or affront anything that was protected under the various discrimination acts in place. And for instance, that could include confronting or offending somebody on the basis of their sexuality or their gender identity, for instance. Now, by taking away, for instance, I'll use the Christian example, by taking away the ability of a religious school, a Christian school, to be able to teach those parts of the Bible that aren't currently in fashion, you would in effect strip those schools from the ability to not only teach the whole of their faith, but to build the culture within the school that is the product of their faith. And that's precisely what parents are looking for when they enroll their kids in that school. Because if they didn't want that, they would have gone to the local public school. The consequence of it would have been, in my view, the effective end of there being true choice for a parent in the kind of education that you can get for your kids. Almost a secularization of all schools by stealth. Now, of course, nobody wants to see a vulnerable young person who's obviously got struggles about their sexual or gender identity going on facing a tough time. Of course, that goes without saying, but the overwhelming evidence that was available at the time was that schools of a faith-based bent that were confronted with these situations were dealing with them overwhelmingly in a compassionate and caring and pastoral way. There wasn't an evidentiary basis for this. And that was deeply troubling too. The other thing that was concerning about the bill was that in the way that it framed the concept of religious education, it didn't just go to the local, faith-based primary school or high school. It extended into the faith-based kindy, the faith-based university, the Sunday school. I'd like to take my kids to Sunday school because I want them to learn about my faith, but their faith. If you're going to provide a layer of discrimination or censorship of what you can teach from Sunday school, or indeed what can be taught in a sermon from the pulpit to parishioners, then we would have gone down a path that would be deeply oppressive to people of faith, in my view. So I had very strong views against it and was very pleased to see that bill defeated. But the real challenge at the time was helping people to understand that subtlety and to push beyond the glib one-liner that was appealing to the press. Because it wasn't until you got into the detail that you'd go, oh, sugar, this does some really, really bad stuff. Of course, nobody wants to see gay kids get a hard time, but that's not what this bill does. This bill doesn't help them, and this bill does a lot of harm. It, in many ways, was a very emotionally charged hangover from the same-sex marriage debate.
Towards the end of last year, there was considerable political and public interest in delivering a federal religious discrimination bill. You welcomed the bill, but with reservations, questioning whether such a bill was the ideal vehicle to protect religious freedom. Can you flesh out those reservations and also touch on your view?
Yeah, look, I can explain my perspective. Look, in a perfect world, this is not the best way to do this, right? The best way to do this is to acknowledge the source of the problem, which comes from the discrimination acts that are the product of this post-World War II international human rights law push, and the way that they have been implemented to unhealthily stifle the ability of people of faith to express themselves. The perfect solution, from my perspective, involves the rolling back of the weapons that exist in those acts. I won't delve into the details of how you do that, but those acts do too much to people of faith at this point in time, and they are the essence of the problem. The solution, I think, lies in paring that back. But as you know, this world is not necessarily a perfect place, and indeed democracy is about sort of mediating all the different perspectives to get the best possible achievable solution. And so if I can't have what I think is the perfect choice, which is a return to natural law and the correction of many of the errors that are at the source of this legal and cultural problem, then what we can do instead is try and level the playing field so that people of faith have a degree of protection from those weapons being turned on them in circumstances where they're really just going about the articulation and living of their faith. And that's what the Religious Discrimination Bill aims to do in a number of facets of human life. So it defines religious belief or activity as a person's holding or not holding a religious belief, or engaging, not engaging, or refusing to engage in lawful religious activity. Concepts that can be really hard to articulate in legislation in a way that doesn't have unintended consequences, but that's what it aims to do. It deals with direct discrimination. So that's where a person treats another person less favourably than another in similar circumstances on the basis of that person's religious belief or activity. And it also deals with indirect discrimination. So where there's an apparently neutral condition, something that seems like it's benign enough, but it has a practical effect of disadvantaging people with a particular religious belief who engage in their religious activity. So when you're dealing with indirect discrimination, there's, I guess, something of a defence that says it's not indirect discrimination if that condition, requirement or practice is reasonable in all of the circumstances. I'm not going to dress it up for you. Discrimination law is really complex. This is a fussy, tricky way to solve a problem that is really about the human experience of just being good to one another, right? Just being able to politely and respectfully express what we believe, and to be able to politely and respectfully cope when we don't hear from others what we believe. In many ways, when you look at the complexity of the legislation, it reaffirms the point that this is an imperfect solution, but it's a genuine attempt to level that playing field so that people of faith don't have to go about their lives treading on eggshells to simply exercise that fundamental ability to do what is, for many, many people, myself included, the very core of who we are. I think that's really important. So it's an attempt to level that playing field. It is genuine in that attempt. It tries to balance a number of competing considerations, and that's a hard thing to do well. And I'll give you an example. We want to protect as much as is possible the right of a person to live according to their faith, but if taken to its extreme, it could make certain business arrangements quite unworkable, for instance. So there's an element of balancing competing priorities in a way that is hard, particularly when for people of faith, their faith is absolute, and there is an attempt to provide people of faith with a whole bunch of really strong shields with which they can protect themselves from the weapons that exist in existing discrimination law and that are so often turned against people of faith. I think that's probably the simplest way of trying to say what it does.
Passage of that bill was disrupted by the bushfires that struck Australia at the end of last year, as well as the COVID-19 crisis. What are the
been a big year, hasn't it?
Yeah, very
It's
big year
been a
indeed.
really big year.
What are the prospects of the bill returning in 2021, and what will help to generate interest in its importance?
Look, I remain optimistic that the bill will face the Parliament. It was a commitment that the Coalition took to the last election. I know that I and many colleagues remain deeply committed to honouring that commitment. And there was, I think, a hope pre-bushfires and COVID that we would be able to do that this year. And as you know, there's been a consultation process that's gone through 2 stages, exposure drafts that have been released that show a lot of the work on the bill has been done, although the final form of it has not been released. I suspect we aren't all that far away from its final form in the version that has been circulated after the second round of consultations. But will we get to it this year? That seems unlikely given how close we are to the end of this year, but I remain very optimistic that it will be an early priority next year. That's me speaking. That's not me having inside information of some kind, but I remain very hopeful that it will be something done very soon. And I know that there are many colleagues that feel very strongly about this and who care deeply about its introduction as the commitment we made to the electorate being fulfilled.
As someone who has a deep knowledge of the law as well as experience in political realities and process, where do you think Australia is heading on matters of free speech and religion?
I think this bill reflects the next frontier of free speech and religion. The way that the Parliament confronts and the extent to which they are able to maturely and without hysteria engage with and debate this bill, and it's my hope and prayer that they pass this bill. I think that will determine a lot about the quality of free speech and religious freedom in this country into the future. Can I add this? There is a group of people in a number of faith communities that I've talked to, and they are smart, capable, well-informed people. They've been following the bill and they know in many ways what they're talking about. And I respect their views very deeply. But they say this bill isn't perfect, this bill doesn't go far enough, and so we don't want it. I'd suggest that view reflects ideological purity, which I can respect, absolutely, but it reflects a political naivety. The opportunity we have here to lock down and, albeit imperfect, but a measure of religious freedom in a concrete and meaningful way is a political moment we have not had in this country for a very long time, and it is the first opportunity in an environment where there has been a lot of social change accepted at the legal level for there to be any measure of respect or protection accorded to those people who don't necessarily want to sign up to those social changes. If you were on the other side of the debate, if you take, for instance, the gay rights lobby or the transgender lobby, they relentlessly campaign and they take many small wins on the path to where they want to be. They lock down a little something and then they start work towards the next thing. And then they lock down a little something and they keep working towards the next thing. From people who say this bill isn't perfect, therefore I don't want it, I'd say that's to approach the question the wrong way. This isn't a one-off opportunity or a one-off requirement that religious people pay attention to what's going on in politics and get something that matters to them. This needs to be the start of a permanent engagement of people of faith in the political process, a permanent building of capacity to stand up for the things you need to be able to live according to faith freely and to allow individuals the freedom that's needed for them to make personal decisions about whether to come to God. That's very important. People always say, on the other side that is, we don't want this bill because we don't want you forcing your religion on us. And that reflects, I think, a really deep misunderstanding of what people of faith seek. And it reflects a deep misunderstanding of the nature of faith itself. Now, of course, my understanding of the Christian faith is better than that of other faiths. So for those of other faith traditions, forgive my, reference only to my own frame of reference here. But God gave individuals free will, and he did it so that they could make choices as individuals freely to come to him and to make their own choice to live according to God's word. To impose upon other people a faith, to force religion on anybody, doesn't save souls. It doesn't do anything for religion. It doesn't do anything for God. It would be entirely counterproductive. And I think we could get a long way towards the correction of a lot of the misunderstandings that underpin this anti-religious sentiment in parts of our community if people just understood that very one thing. This isn't about trying to force religion on anybody. Quite frankly, that just doesn't work. Not in the theological sense or in the political sense. But this is about preserving the freedom of thought and the freedom of choice and the freedom of action that allows a person the opportunity to genuinely choose their own adventure. And that might mean faith for them or it might not. But unless we preserve that space, none of us get to find out.
Senator Stoker, thank you for your time and for speaking with us today on Talking Freely.
Thanks for having me.
That's it for our latest episode of Talking Freely. If you'd like to get in contact with us, you can do so through our website, www.freedomforfaith.org.au. Freedom for Faith exists through the generous donations of individuals and organisations across Australia. If you'd like to financially partner with us, you can do so through our website.